My Lords, the Honorable Chief Justice, Shri Alok Aradhe, my Lord, the Honorable Judges, former Judges of the Honorable High Court, the Chairman of the Bar Council, Member Bar Council of India, the Additional Solicitor General of India, the Deputy Solicitor General of India, the Additional Advocate General, the Public Prosecutor, the President, Telangana High Court Advocates Association, the Registrars, the Director Judicial Academy, the Law Secretary, Telangana State Legal Services Authority, the law officers and other officers, respected senior members of the bar and junior advocates, friends and family members of Sri Justice Munnuru Lakshman and Srimati Justice Gunnu Anupama Chakravarthy, ladies and gentlemen. We have assembled before the full court today to bid farewell to Honorable Sri Justice Munnuru Lakshman and Honorable Srimati Justice Gunnu Anupama Chakravarthy, beloved judges of our High Court for the state of Telangana, on the transfer to Rajasthan High Court and Patna High Court respectively. Justice Sri M. Lakshman was born at Velchal village, Rangareddy district, to Sri M. Adivaya and Srimati Rukamma. His Lordship did his primary school education in Velchal Primary School, upper primary education in ZPHS Kohir, intermediate in SAP College, Vikarabad, and Government Junior College, Tandur. His Lordship graduated with BSc from PG College of Science, Saifabad, and with LLB from Usmania University College, Hyderabad. His Lordship pursued his LLM from PG College of Usmania University, Hyderabad. His Lordship enrolled as an advocate in the year 1991 in the Bar Council of AP and actively practiced in civil and criminal and all other branches of law and appeared before all the courts in Hyderabad and Rangareddy district, including revenue authorities. His Lordship was appointed as a district judge in the year 2008 and worked as district judge of Mahbubnagar, Nizamabad and Hyderabad districts. His Lordship worked as principal district judge of Warangal and Khammam districts and as the presiding officer of Labour Court, Hyderabad. His Lordship was elevated as Judge of High Court for the state of Telangana on 15th October 2021. It is fitting to refer to some of the notable judgments rendered by His Lordship as Judge of this court that speaks of His Lordship's great legal acumen. In Sunkam Shankaraya versus State of AP, Criminal RC 1204 of 2009 and batch, an interesting question arose before His Lordships, that is with regard to the non-speaking docket orders in certain criminal revision cases, either allowing them or dismissing them, but with no clear reasons for the same, passed by a former judge of the court who expired due to ailment. Therefore, the said cases were placed before His Lordships for appropriate orders to be passed. The preliminary questions that fell for consideration before His Lordships were that whether the orders which are passed by docket proceedings constituted valid final orders or judgments in a general sense. If not so, what is the resultant effect of such orders? If such orders are found to be a nullity, whether the court can exercise power to either recall or review in the absence of any statutory provision expressly conferring such a power on this court. More so in the light of the provision contained under Section 362 of the Criminal Procedure Code. His Lordships, on due consideration of Sections 353, 354, 387 of the Code, held that it is the cardinal principle of law that in every judgment or final order, the basic requirements are the facts in dispute, points for determination, and the decision of the court on such points or issues, and the reasons for such a decision. Judgment or a final order has to be pronounced by delivering the whole of the judgment or by reading out the operative portion of the judgment. The first mode of delivery of whole of the judgment arises in a situation where in an open court the judgment or final order in the presence of parties or their counsel is dictated, and the second and third mode arise where the court reserves the judgment, and after the judgment is dictated and typed, such a judgment is pronounced in the open court by reading out the whole of the judgment or reading out only the operative portion of the judgment. After such pronouncement, each page of such judgment has to be signed. From the above said procedure, what is indicated is that the judgment final orders must contain not only the resultant portion but also must contain all the requirements of a final order judgment, including reasons. In the present case, such essential aspects are absent, and further, any final order of judgment devoid of reasons is a nullity. Therefore, complete absence of reasons in the docket orders were held to be null and void by his lordships. Further, with regard to the court's power to recall or review such orders under the CRPC, his lordships, after examining sections 362, 482, and 369, and relying upon the ratio laid down by the apex court in the landmark judgment of Grindlays Bank Limited, with regard to expression, review, and the distinction made between procedural review and substantive review, and such distinction which was made in civil cases being accepted in criminal cases by the apex court in Ganesh Patel versus Umakant Rajoria's case, held that every court or tribunal exercising criminal jurisdiction has a power to review with regard to procedural lapses which are of such serious nature as to tantamount to nullity, and no court, including the High Court, while exercising criminal jurisdiction, has an inherent power to review orders on merits once judgment has been pronounced and signed. In the light of the above findings, the docket orders either allowing or dismissing the revisions passed by this court on various dates were recalled and restored to the files by his lordships. In Andhra Pradesh Industrial Infrastructure Company Limited versus A.K. Sagar and others, AS number 987 of 1993, in which I had the occasion to appear before his lordships. An appeal was filed assailing the judgment and decree in OS 47 of 1982, whereby the suit filed by the respondent therein for specific performance of contract was decreed. Brief facts of the case are that the original plaintiff made an application to the defendant to allot land about 120 acres in industrial development area and paid rupees 5,000 towards initial deposit, and the defendant issued order allotting land to an extent of 120 acres on an outright sale basis at a provisional rate of 4,600 per acre. The said allotment order contained other terms and conditions. Plaintiff also paid an amount of rupees 5,000 towards acre 95 land, which was reserved for raw material and situated adjacent to the land to an extent of acre 25 untas, which was already allotted, and possession was delivered under execution of agreement of sale in terms of allotment letter. Defendant cancelled the allotment of acre 95. Plaintiff addressed letter requesting the defendant to reconsider the cancellation order. As there was no response from the defendant, the suit was filed and the court granted a decree of specific performance to the respondents therein, directing the appellant complete allotment of the land. His lordships allowed the appeal, holding that there was no enforceable contract of sale for the entire extent of land and that the respondent had not showed his willingness to perform his part of the contract, in the absence of which a decree for specific performance could not have been granted by the court. His lordship further held that the assignment of interest by the original allottee company, which was renamed later in favor of the respondent herein, who was the plaintiff subsequently, is not valid, since originally the suit was filed by the original allottee company and was substituted with the respondent in the appeal by virtue of order passed in an interlocutory application filed by the respondent under Order 6, Rule 17 of the CPC. His lordship observed that GPA creates only an agency and the holder of GPA is the agent of principal. In the present case, since the principal himself was sought to be substituted with the agent, which is a procedure unknown to law, and the basic requirement not being considered by the court below, held that the respondent could have continued the suit proceedings being the representative of the original plaintiff only if there is a valid assignment of interest held by the plaintiff during the pendency of the suit proceedings, and such assignment must be permissible under contract entered between the original plaintiff and the defendant. Keeping in mind that there is a condition in the agreement which clearly prohibits any assignment and subletting. The plaintiff cannot ignore such a written contract and create a new assignment by whatsoever means. Therefore, the respondent was held to be not competent to prosecute the present litigation on account of prohibition of assignment in the contract, and the appeal was allowed accordingly. In Special Deputy Collector and Land Acquisition Officer SRSP LA Unit Warangal versus Myakala Veera Reddy and others, the main question before the division bench was whether the reference court could have granted statutory benefits from the date of taking possession of the lands, as the possession of lands in the present case was taken under notification that had lapsed anterior to the date of subsequent valid notification. His Lordship, speaking for the bench, held that the commencement of benefits under Section 23(1)(a) is from the date of issuance of preliminary notification, and the terminal point is either date of award or the taking possession of the land, whichever is earlier. Since the possession is under invalid notification, the terminal point to be taken is the date of the award. Therefore, the respondents are entitled for the benefits under Section 23(1)(a) of the Act from the date of subsequent notifications to the date of award. Since the possession was taken invoking urgency clause, and a valid possession under Section 17 of the Act invoking urgency clause or under Section 16 of the Act can only be taken after passing of the award, any possession under invalid notification is not valid possession under the Act. Therefore, the statutory benefits of the Act are not extendable for the said period of invalid possession held by the government. His Lordship further held that the landowners are entitled for rent or damages toward use and occupation for the period the government took possession until the date of passing of award. Honorable Srimati Justice Gunnu Anupama Chakravarthy is born to Dr. N. Krishna Chandra Rao and Srimati Mahalakshmi on 21st March 1970 at Palakunda village of Srikakulam district. Her Lordships completed 5 years law course from NBM Law College, Visakhapatnam. Her Lordship is married to Sri G. LAXMAN Rao and blessed with a son, Abhishek Rutvik, who is a practicing advocate. His Lordship commenced her practice in the erstwhile High Court of Andhra Pradesh after her enrollment in the year 1994. Her Lordship started working in the office of a senior advocate, Sri T. Niranjan Reddy, and dealt with cases relating to civil, criminal, writ jurisdiction in the High Court, and also attended civil criminal courts apart from cooperative and other tribunals. Her Lordship was appointed as Assistant Government Pleader in the year 2006 and worked as such till 2008. Her Lordships, after pursuing her Masters in Law, was selected as District Judge under direct recruitment and joined the service as Additional District Judge on 2nd November 2008. Her Lordships worked at various places in the erstwhile state of Andhra Pradesh as Judicial Officer. Her Lordships worked as Principal District Judge Karimnagar from January 2019 to September 2020, as Member Secretary, Telangana State Legal Services Authority at Hyderabad till August 2021, as Registrar General of High Court for a brief period, as Chairperson of Cooperative Tribunal Hyderabad, and as the Chairperson of Telangana State VAT Tribunal, Hyderabad in the unified state of Andhra Pradesh. Her Lordship also delivered guest lectures in Judicial Academy Secunderabad and in Nalsar University of Law, Hyderabad. Her Lordship was elevated to the bench and sworn in as Judge of High Court for the state of Telangana on 24th March 2022. It is apt to refer to few judgments rendered by Her Lordships on the occasion that speak to Her Lordship's legal aptitude and remarkable adjudicatory abilities. In Kancharana Sri Priya versus State of Telangana, criminal petition number 5588 of 2023, a petition was filed by an accused who was arraigned in accused number 4 to quash the docket order passed by the 3rd Additional Junior Civil Judge cum 10th Additional Metropolitan Magistrate at Medchal, Malkajgiri district. The respondent had filed a complaint accusing her husband and her parents and the petitioner herein, who is cousin of husband, of committing offences under Section 498 of IPC and Section 3 and 4 of Dowry Prohibition Act 1961. The contention of the petitioner was that though the case was registered against 4 accused, who were the husband of the respondent, her in-laws and cousin sister of husband of respondent, the police have investigated and filed charge sheet only against accused numbers 1 to 3 by deleting the name of accused number 4. Though police after due investigation have filed charge sheet only against accused 1 to 3, as per the docket order passed by the trial court, cognizance was taken against accused 1 to 4 basing on sworn statements of LW 1 to 3. On the other hand, Lend Assistant Public Prosecutor contended that basing on the sworn statement of the witnesses, the trial court has taken cognizance against accused 1 to 4, though charge sheet is not filed against petitioner accused number 4. Therefore, prayed to dismiss the criminal petition. Her Lordship, while dealing with the case, made a detailed reference to the provisions of CRPC and expostulated the distinct procedures set out in the court in case of warrant cases and in private complaint. On such a thorough examination of the procedure envisaged by the court, in the present case, Her Lordship held that since the record does not reveal that a protest petition was filed by respondent number 2 de facto complainant, and since in a warrant case the question of recording sworn statement will not arise and it will only arise in a private complaint, the trial court could not have equated the procedure for private complaint under section 200 CRPC with that of the warrant case. Thus, if at all, de facto complainant is aggrieved by deletion of the names of the accused, she can file a petition under 319 of CRPC before the concerned court at appropriate stage. Furthermore, so far as involvement of petitioner accused number 4 in the case is concerned, the statements of LW 1 to 3 recorded under section 161 CRPC are inadequate and no allegations are leveled against the petitioner accused number 4. However, the trial court, after considering the sworn statement of witnesses, which are quite contrary to the statements of the witnesses under section 161 of CRPC, with regard to the involvement of accused number 4 in the offence, took cognizance of the case against the petitioner for the offences punishable under section 498A of IPC and section 3 and 4 of Dowry Prohibition Act, which is unjustified. Therefore, Her Lordship set aside the docket order passed by the trial court. In Madinam Raju versus B. Sainath and another, MACMA 267 of 2018, the appellant filed an appeal asking for right compensation as he was aggrieved by the decree given by the Motor Accident Claims Tribunal. According to him, he was entitled to a compensation of rupees 6 lakhs, but to his dismay, the tribunal awarded him an amount of 1,96,000 only. The deceased who passed away in the accident due to the negligence of respondent was the mother of the claimant, who used to earn 15,000 per month by selling vegetables, and since the petitioner was the son of the deceased, was entitled to compensation towards parental consortium. On the other hand, the insurance company argued that the claimant was not entitled to the parental consortium as he no more falls under the definition of child. Her Lordships, after an analysis of the Act and the laws laid down by the Supreme Court in the Magma General Insurance case, held that a parental consortium under the Act is a type of compensation that is awarded to children who lost their parent in a motor vehicle accident, and that is only granted when there occurs a premature death of one of the parents due to an accident. It is compensation given to the child for loss of parental aid, affection, protection, discipline, society, guidance, training, etc. Therefore, Her Lordships held that since in the present case the claimant asking for compensation is a 50-year-old man, and as such he cannot be entitled to compensation under the head of the parental consortium. In Muhammad Umair Mehdi Khan versus State of Telangana, Criminal Revision Case number 279 of 2023, criminal revision case was filed seeking to set aside the order of special judge for trial of protection of children from sexual offences Act cases, which confirmed the orders of the magistrate to treat the juvenile accused as adults. Her Lordships, after a thorough examination of the provisions of Juvenile Justice, Care and Protection of Children Model Rules 2016 and the guidelines issued by the Apex Court in Barun Chandra Thakur versus Master Bolu and another 2022 SCC Online SC 870, and exercising the High Court's power under Section 102 of the Juvenile Justice Care and Protection of Children Act 2015 to call for record of any proceeding which any committee or board or children's court or court passed an order for the purpose of satisfying itself as to the legality or propriety of any such order found that there was a denial of adequate opportunity for the juveniles as the documents were not supplied as per Rule 10.5 of the Juvenile Justice Care and Protection Children Model Rules 2016. Further, Her Lordships observed that the learned magistrate has stated no reasons for differing with the findings of the board member that the children in conflict with law in the present case were unable to understand the legal consequences of their actions. And further, it is evident that within one day the entire assessment was done and the learned magistrate, without adequate reasons, has differed with the board's findings and came to the conclusion that the CCLs are mentally and physically fit and can be prosecuted as adults. Therefore, Her Lordships remanded the matter to the 5th Additional Chief Metropolitan Magistrate cum Principal Magistrate of Juvenile Justice Board for conducting inquiry afresh as contemplated under Rule 10.5 of the Juvenile Justice Care and Protection of Children Model Rules 2016 and for passing orders afresh. The absence of His Lordship Sri Justice M. Lakshman and Her Lordship Srimati Justice G. Anupama Chakravarthy will be felt by all of us, but their tenure in this court will remain etched in the minds and hearts of all the members of our legal fraternity forever. I, on behalf of my colleagues, give our best wishes to His Lordship Sri Justice Munnuri Lakshman and Her Lordship Srimati Justice Gunnu Anupama Chakravarthy on their transfer to Rajasthan High Court and Patna High Court respectively. And I pray the Almighty to bestow strength and success in all endeavors that may undertake in future. Thank you, my Lord.
My esteemed colleagues on the bench, Mr. B. Narsim Sharma, Additional Solicitor General of India, Mr. B. S. Prasad, Learned Advocate General, Mr. J. Ramchandra Rao, Additional Advocate General, Mr. A. Narasimha Reddy, Chairman, Bar Council of Telangana, Mr. P. Nageswar Rao, President, Telangana High Court Advocates Association, Mr. G. Praveen Kumar, Deputy Solicitor General of India, learned senior advocates, learned members of the bar, registrar and members of staff of the High Court, Director Judicial Academy, representatives from press and media, family members of Brother Justice M. Lakshman and Sister Justice G. Anupama Chakravarthy, ladies and gentlemen. We have assembled here to bid a warm and affectionate farewell to our Brother Justice M. Lakshman and Sister Srimati Justice G. Anupama Chakravarthy on their transfer to High Court of Rajasthan and High Court of Judicature at Patna, respectively. Mr. Justice M. Lakshman was born on 24 December 1965 at Velchal village of Rangareddy district to late Shri M. Adivaya and late Srimati Rukmamma. He passed his intermediate examination from SAP College, Vikarabad and obtained bachelor's degree in science from PG College of Science, Safarabad. Justice M. Lakshman secured LLB degree from Osmania University College, Hyderabad and a master's degree in law from PG College of Osmania, Hyderabad. He was enrolled as an advocate in the year 1991 in the erstwhile Bar Council of Andhra Pradesh and dealt with civil, criminal and other matters in all courts in Hyderabad and Rangareddy district. He was appointed as district and session judge and assumed charge as such on 3rd of November 2008. He served the district judiciary at various places in the state, that is Mahmood, Nizamabad and Hyderabad. Justice M. Lakshman was also posted as principal district judge at Warangal and Khammam districts. He also had the opportunity to serve as presiding officer of Labour Court 1, Hyderabad. Justice M. Lakshman was elected as judge of this court on 15th of October 2021. Justice M. Lakshman, prior to his elevation, served for more than a decade in district judiciary. The rich experience as a judicial officer helped him in performing the duties as judge of this court effectively. He was part of various administrative committees and actively participated in the deliberations of the committees. On the administrative side also, Justice M. Lakshman shouldered the responsibility effectively as an administrative judge of various districts in the state. Justice M. Lakshman, during his tenure as a judge of this court, decided 2,484 cases, including division bench matters. The law report bear a testimony to his competence and caliber. Justice M. Lakshman is happily married to Srimati Nagumati and they are blessed with a daughter Shreya, who is pursuing her masters in US, and a son Akhil, who is a third-year student of law course. I, on my own behalf, as well as on behalf of sister and brother judges, and on behalf of the entire legal fraternity of state of Telangana, bid farewell to Brother Justice M. Lakshman and wish him a successful tenure as judge of Rajasthan High Court. We wish him and his family members peace, prosperity, health, and happiness for years to come. Srimati Justice G. Anupama Chakravarthy was born to Dr. M. Krishnachandra Rao and Srimati Mahalakshmi on 21st March 1970 in the erstwhile state of Andhra Pradesh. She obtained her law degree from NBN Law College, Visakhapatnam, and secured her master's degree in law from Nagarjuna University. She started her practice in the chambers of Sri T. Niranjan Reddy, senior advocate, and dealt with writ petitions, civil as well as criminal cases. She was appointed as assistant government pleader in the year 2006 and worked as such till 2008. Justice G. Anupama Chakravarthy was appointed as district judge and joined as such on 2nd of November 2008. She served district judiciary in the capacity of additional district judge, principal district judge, and was also posted as member secretary, Telangana State Legal Service Authority, and as Registrar General, High Court for the state of Telangana. Justice G. Anupama Chakravarthy had an academic bent of mind and delivered lectures in Judicial Academy as well as Nalsar University of Law, Hyderabad. She was elevated as a judge of this court and took oath on 24th March 2022. Her long experience for more than a decade in the district judiciary has helped her to perform the duties as judge of this court efficiently. She was part of various committees and participated in the deliberations of the committees wholeheartedly. On administrative side also, Justice V. Anupama Chakravarthy shouldered the responsibility effectively as an administrative judge of various districts in the state. She, during her tenure as a judge of this court, has decided 4,225 cases, including division bench cases. The law reports bear a testimony to her erudition. Justice G. Anupama Chakravarthy is happily married to Shri G. Lakshman Rao and is blessed with a son, Mr. Abhishek Ritvik, a practicing advocate. I, on my behalf as well as on behalf of entire judicial fraternity of state of Telangana, pray and bid a warm and affectionate farewell to Sister Justice G. Anupama Chakravarthy and wish her a successful tenure as Judge of High Court of Patna. We wish her and her family members peace, prosperity, health, and happiness in years to come. Thank you.
My hearty pranams to the Honorable Chief Justice, Sri Alok Aradhe Garu, learned brothers and sister judges, Sri B.S. Prasad, learned Advocate General, Sri B. Narasimha Sharma, learned Additional Solicitor General, B. Rajendra Reddy Garu, learned Public Prosecutor, A. Narasimha Reddy Garu, Chairman Bar Council of Telangana, J. Ramchandra Rao, Additional Advocate General, G. Praveen Kumar, Deputy Solicitor General, Alaya Nageshwar Rao, President High Court of High Court Association, Registrars, Director, Judicial Academy, Member Secretary, State Legal Services Authority, Special Government Pleaders, Assistant Government Pleaders, Standing Councils, Law Officers of the State and Central Government, members of the Bar Council of Telangana, members of the legal fraternity, including designated senior advocates, seniors and junior advocates. Joint registrars, deputy registrars, assistant registrars, section officers, and staff of the High Court, my family members, relatives, and friends, ladies and gentlemen, good afternoon to one and all. I feel pleasure and bliss to witness the gathering for bidding farewell to us. I have enrolled in the Bar Council on 30/11/1994. Till the date of my appointment as district judge, I practiced in this High Court and I was with the office of the learned senior counsel Sri T. Niranjan Reddy Garu, where I have learnt work, principles, and disciplines. Sri T. Chandrasekhar Reddy Garu, retired district judge, is the father of Mr. T. Niranjan Reddy sir, and is an inspiration for me for becoming a judge. On this platform, I convey my heartfelt thanks to my gurus T. Niranjan Reddy Garu and his father T. Chandrasekhar Reddy Garu. It is a proud moment for me for becoming the judge of this court, as I have started my career from the corridors of this High Court. Today, what I am is because of my family members, especially my parents, husband, son, brothers, and my guru. With their cooperation and support, I am standing before all of you. I thank each and every advocate for their support in smooth discharge of my functions. I tender my apologies if I happen to hurt any one of the advocates during the discharge of my judicial duties. I acknowledge the services rendered by my personal secretaries, court officers, court masters who have attended my court, personal attendants attached to my chambers, drivers, posting clerks, for their unstained cooperation and coordination, rendering in smooth, effective functioning of my office, and the same is highly appreciable. I am also thankful for the staff attached to my residence for making me comfortable with their services, and also for my PSOs for looking after my security. My sincere thanks to the joint registrar buildings, deputy registrar buildings, assistant registrar, posting section, section officers, J Special Administration, and the team members, including the overseer. My special thanks to the protocol staff and for their innumerable services. I also thank the medical staff for their services. I also thank the Special Police Protection Force for the state of Telangana for providing security during my tenure. If I have not mentioned anyone, it is only my inadvertent and not intentional. The loads of memories with me will follow me forever. The love and affection showered by you all means a lot to me and will be cherished throughout my life. I pray the Almighty to shower His choice blessings on you all. Finally, I would say one thing: don't ever chase money. Once you start chasing money, you have to chase till your life end. These words were taught to me by one great personality, Honorable Justice P.S. Mishra, while I was the then advocate, and I should be ever thankful for him. Concludingly, I would say, acquire knowledge. Once you acquire knowledge, money starts chasing you, and it will be till your life end. This would be only my suggestion for the junior advocates of this bar. I once again thanks to each and everyone, and my sincere thanks to my brother judges and to the Honorable Chief Justice, who has kept me in a very comfortable position. Thank you one and all.
Honorable Chief Justice Alok Aradhe Garu and B.S. Prasad, and my colleagues on the bench, and Mr. B.S. Prasad, Advocate General, and Narasimha Sharma, Additional Solicitor General, and A. Narasimha Reddy Garu, Bar Council Chairman, Rajendra Reddy, Public Prosecutor, Deputy Solicitor General Praveen, and other senior advocates who are here, and other members of the bar, and registry, all the registrars, the law secretary, as well as the secretary, legal service authority, and my wife Madhumati and my son Akil, who are here, and family members of my colleague ANUPAMA CHAKRAVARTHY, Mr. LAXMAN Rao, other ladies and gentlemen, very good afternoon to you. First of all, I must say thanks to the Chief Justice as well as the B.S. Prasad, who are kind enough to speak about me, expressing affectionate and pleasing, courteous words on me in assessing my ability to discharge judge at this court. It is a mixed feeling here to live here, a feeling of a new bride leaving parental home And this feeling is not a first marriage feeling, it is a marriage of third or fourth time. Since the reason is, we are experiencing the transfer is not new to us because we came from the district judiciary. We had experience of transfer from one place to other place. And this is one such a transfer, which is an incidence of service jurisprudence. We can't avoid it. It is when we accept the service, we must face to accept the transfer. This is part of it. It is not a new. And it also promotes unionism because transfer from one state to other states, it brings the bonds between two states. It's an opportunity to go there. And it's also great pleasure while working here among the various reputed seniors who are here. And it is a great opportunity to enhance my abilities, both in civil and criminal and other subjects where I could do the best of my abilities to the satisfaction of all the bar members. I don't say that all the members are satisfied. If all are satisfied, is not a good judge. Only 50% is enough for making a good judge. No, I hope that I secure the 50% of support from the advocates when they visit and said about me words, kind words. This shows that I discharged my duties to the satisfaction of the bar. That feeling I may be leaving from here. Now, I had two opportunities here. As a district judiciary, we have the same batchmates. We are here, we are elevated, we have the good company of it. And as a judge, we elevated from the advocacy. No, we have also good rapport with them because I also practiced here as a sufficient time as an advocate. Though it may not be like a senior and reputed advocate here, I'm a small advocate then. And having the practice from bottom level to all courts, in experience of all laws. And that started my career. In fact, the entry of myself in the judiciary is an accident. I never thought that my pursuing law is not to join any profession. In fact, it is a step in the university to have this shelter to prepare the competitive examinations. Ultimately, I tasted the practice fruits. Then I started ignoring the employment efforts. No, I started practice here initially with criminal practice, V.V. Kishan. Later, I shifted to HIGHCOURT with Vijay Kumar Devineni. It is occasion to learn many things from them. And it's a great thing to practice here because of various dimensions of law. I could acquire better skills. And my entry in the judiciary is also accident. I never intentionally prepared for getting into service. It is lucky enough that I had law is one of the options in my competitive examinations. That subject has given fetching for me into entry into the judicial service. These are all my short experience in initial days. I'm still in the dilemma to continue the profession or to discard. Ultimately, we continued, and if you turn back, I'm seeing that we're really very fortunate to have occupied this kind of position. And it's a great thing for a person like me who hails from a small middle class farmers from a rural village without having any back support of legal or anything. It's a great opportunity. And I hope that I earn all your affections, and I also had a good company of my colleague judges, and the Chief Justice, who is kind enough to accommodate all things, and he is also compassionate and cordial to each of the members on the bench. And the only victim is of transfer is, I told in the afternoon also, my wife is the victim. No, I'm not, I prepared for myself to get anywhere to work. The judge has to work anywhere, a servant like him. She happened to be here only. She's a assistant professor here, and my son is a law final year. And my daughter is recently went to US to pursue her post-graduation. And this is, when I joined this, I thought that I am free from transfer. No, transfer, no, I felt mistake. The transfer is always hangs on the head of the individual who accepted the service. And also I could able to perform my functions effectively, and I greatly indebted to all seniors, eminent who are assisted me in discharge of my duties to enlighten myself in a better position than which I was having when I joined in the service here. And I must say, all the members here, one thing to the juniors, one thing, fear suppress the intellectuality. Fearless advocate only he gets a successful lawyer. But don't get fear, and don't think that the judges know everything. Judges is also human being, and you better advocacy leads to better judgments and better disposal. That advocacy you have to inculcate and proceed with. And I must also thanks my staff, particularly personal secretaries, Jagan Reddy and Rahul and Courtmaster Gafur and other court officer. Probably they must have been experienced my anger also sometimes, and but for them only I could able to dispose civil cases. Fortunately, unfortunately, I was in the civil judge from old cases from my appointment here. A few exceptions is the division bench heading and bails. That is now whatever the subjects which are assigned to me, I could able to discharge to the satisfaction of all the advocates, and I could able to hear. And while I'm the top judge for assignment because most of them must have been aggrieved by my toughness. That toughness is the only necessity of proper conducting of court management. Because in the old cases, if I don't be tough, very difficult to retain the advocates in my court. Now, except myself, I have to sit and without any advocates, which is impossible to disposal. No, I also apologize for anybody who had, on account of my toughness in the adjournment or in non-granting of adjournments. And I all thanks the registry and everyone, particularly protocol and registrar general, other registrars and registrar management, everything, and everyone who cooperated me for successful discharge of my services here. And I enjoyed all the amenities which I could provide. Thank you everyone.